All rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Suk-Young Shin. To my left is Justice Maureen Walsh. We are the panel hearing the 6 cases on the list this morning. I know most of you have been here before, but just a brief reminder, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials, so you should get right to the substance of your argument. In the event that your case is impounded or partially impounded, I will remind you of that before it's called, but please be mindful when you approach the podium as to whether or not that is your situation. I will now call the first case on the list, Commonwealth versus David Juden. I'm sorry if I've mispronounced that, 24P488. Good morning, counsel.
Good morning. May it please the court, my name is Emma Quinn Judge, and I represent the defendant David Juden. That is how he pronounces that. We're here because Mr. Juden may have been convicted for conduct with which he was never charged. This appeal is about notice and fundamental fairness, and while I want to focus my arguments today on variance, I will take a moment to talk about preservation since the Commonwealth did raise that specifically. On the topic of preservation, we know that an objection doesn't have to be perfect, but it has to make clear that there is an objection. It has to state the basis for the objection, and the lawyer has to tell the court what they wanted the court to do. So defense counsel said, I would respectfully ask the court to direct out the strangulation, but also not to initiate the assault and battery. That is at page 143. It was clear that he made an objection. The docket notes that the case was amended over his objection. The objection is noted and preserved in the transcript, both at the close of the Commonwealth's case and again at the close of defense counsel's case. So it's clear that there was an objection. So we turn to what the basis for the objection actually was. With respect to my first argument, variance, what he says is that he prepared this as a strangulation case, and I know the court says, well, there's a touching, there has to be a touching and things like that, but this is to a different area. So he is specifically saying the fact that the charge was expanded to go beyond touching Ms. Juden's neck to a harmful touching or an unwanted touching anywhere on her body was the basis for his objection. He also said, quote, the court is deciding as to charge him with a case that is not before this court. So I think he made clear that he was objecting to the change in the sort of factual basis for the charge.
If the change was only that there hadn't been sort of the pressing down, so that the evidence, and I know your client at trial said none of this happened, but if the evidence had been that he put his hand on her neck but hadn't squeezed, so assault and battery is a lesser included of strangulation, would your argument be different? Or is it because we have this whole concept of this whole body touching?
It's because we have this concept of this whole body touching, and because the evidence, the closing arguments, and the jury instructions all allowed a conviction on those other grounds. And I can pivot to the substance of the variance argument if you'd like.
So if the judge had limited the jury in some way to considering only the touching of the neck as an assault and battery, that would be okay.
If the judge had limited the jury to only the touching of the neck, I think that, and a harmful battery as opposed to an offensive battery, but presumably that's, if that goes along with your question, I think that would have been okay. I think it's the different ways in which the charge gets expanded, both as to touchings elsewhere on the body, and the fact that it gets expanded to permit a touching that is not even harmful, right? Because strangulation required a harmful touching. That's implicit in strangulation, but the jury were permitted to consider also an offensive touching, which doesn't have to be harmful, and which there is a consent issue. So it's the expansion of the charges. I can move off. I was going to talk about preservation on the amendment issue if you'd like. I can do that, or I can move off variance. But
well, is it actually an amendment in the traditional sense of amending a charge?
Right. I mean, so the amendment case law covers constructive amendments and amendments that are made by virtue of some sort of motion. So I think it's fine to call it an amendment. And I don't know that it matters what we call it. I mean, clearly on the docket, it was annotated as an amendment. And so the question then becomes, was the change one of form or one of substance? And if it's one of form, you get back to prejudice, which I think then overlaps substantially with what I would say about variance.
Say it was an improper amendment for 3 reasons: that it altered the theory of the case, it added a new element, and it expanded the scope of liability.
That's correct.
Okay. I understand how it altered the theory of the case. The new element, I guess, is the intentional?
No, the new element is that intentional battery has 2 forms. One of them is harmful and one is offensive. And for offensive, you don't have to have a harmful touching, and consent becomes an issue. Consent is not an issue for strangulation or a harmful battery.
And then, is that the same argument as expanded the scope of liability?
Expanding the scope of the liability is really more my variance argument about the neck versus the rest of the body.
Gotcha. I just wanted to make sure I understood.
No, it's...
Can we turn to that neck versus the rest of the body? Because I'm looking again at the trial transcript, and specifically at page 103. And, I'm not just, I hope I'm not, cherry picking here, but, question, was he pushing you down any specific area of your body? Correct, he was pushing me right there, by my neck and my chest. By right there, he was pushing me down with one hand, he was pushing me down. I mean, so almost in many assaults, right, there's generally hands or, but, there's some contact with the body also. But it seems to me that when and tell me where you disagree, that the focus was on the touching of the neck. Understandably at first, strangulation, and then later, which you object in appeal, to the assault and battery. But that answer there seems like the focus was on the neck.
Well, the focus of the Commonwealth's question certainly was on the neck, but there is only one part of the testimony, I believe, where she directly says he put his hand on my neck. The rest of the time, I think on 103, where you're saying it's by my neck, on my chest, 101, 102, 103, 107, 113, she talks about being the hand going on the chest. And so much so that when there was this argument after the Commonwealth rested, the judge said, I would say that with one exception, she generally focused on the chest area. And I go through the references to the neck in the reply brief and point out that he's right about that. She really is focused on the chest area, and the testimony is focused on the chest area. There's also some testimony about contact with the stomach and jumping on her. And in the Commonwealth's closing, the Commonwealth invites the jury to convict for assault and battery on those other grounds. The Commonwealth says that he put his arms to her neck area and chest, and then, without mentioning either of those, says even more specifically, he proceeds to grab her phone, then gets on top of her and uses force in both of his hands, and I would submit to you that that is assault and battery.
So I hear you on that. Let me just ask you this. For a moment, let's say the Commonwealth charge straight assault and battery. No strangulation at all, right? Because they recognized from the testimony of the witness that there was no impediment of her ability to breathe, right? So the straight assault and battery.
Right.
Okay, so on the same facts, nothing has changed, just that the charge was the lesser included. Couldn't the Commonwealth have then argued to the jury, you could find it was this, you could find it was that, you could find it was one of these 4 acts that the defendant did? Couldn't they?
If it were charged from the outset as a straight assault and battery, anything that meets the legal standard, the harmful touching or the offensive touching, it would have been a basis for conviction. Here there are a couple things. One is that was obviously, as you know, it was charged as strangulation. I also want to point out something I noticed when I was reviewing the record again, which is the police report. The police report says he will be charged with MGL Chapter 665, Section 38A, assault and battery, offense, assault aggravated, weapon or force, asphyxiation, choke, strangled, injured where, neck. Someone looked at that police report and actually decided not to charge him of assault and battery. So he not only had noticed that he was being charged of strangulation, but that somebody had looked at the police report and decided not to go forward on those charges. And so what he was charged with was that he did strangle or suffocate. And that's what's in the charging document. And
Sure. And just so I'm clear, you agree that in certain factual scenarios that assault and battery is a lesser included of strangulation?
So I'll answer that, but I want to say two things first, because I think it's relevant. One is, I didn't take a position on this because there isn't, as far as I can see, a Commonwealth case directly addressing this. And I think the Commonwealth agrees on that point. The second is I don't think it's necessary to my appeal, but I will tell you how I do think it could implicate the appeal. I don't think it's necessary to the variance issue. You can have a variance whether the charge changes or doesn't change, right? Because it's about the conduct charged. How does it affect the amendment issue? If all of assault and battery is a lesser included of strangulation, then it can't be a substantive amendment. Then I would concede that it has to be an amendment of form, but you would still then be looking at prejudice. It doesn't resolve the issue. Because, for example, if you are charged with ABDW with a gun, straight assault and battery is clearly a lesser included of that, but if the evidence at trial were that you punched someone in the face, that wouldn't be a lesser included of what you were, not a lesser included, it would be a variance because it wouldn't be what you were charged with.
So could I go back to Justice Walsh's question about if this was charged as a straight assault and battery from the outset, there wouldn't have to be specific unanimity as to the act that constitutes the battery.
That is my understanding. If it had been charged from the outset that way, but it was not charged, and in fact a deliberate decision was made not to charge it. Why is it?
Could it have been charged as 4 separate assault and batteries?
I don't know. I would doubt that it could be charged as 4 separate assault and batteries, but I would have to. I'm not sure the answer to that. I think it's one incident. I think if you identified a series of harmful touchings that were and distinguished between them, perhaps you could do it that way.
So then how do you respond to the Commonwealth's argument that this was a continuous course of conduct, which I gather the import of that to be that it was kind of all or nothing, like it all happened or none of it happened?
Right. Well, I think there are 2 responses to that. One is where the focus was. The focus in the testimony was chest, 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 chest. And so even though the Commonwealth was initially focused on the neck, I think any touching of the neck is incidental to that, and it's not clear what the jury convicted of. I think the other thing about that is to remember that he was also charged with witness intimidation. And so some of this conduct around getting on top of her and grabbing the phone goes to the witness intimidation charge.
That was a not guilty, right?
And that was not guilty. This jury was sifting evidence and not sure they believed everything.
They also had, and we have them in the supplemental appendix, the 4 photos of her, very much focused on the neck and the injuries to the neck.
Right. The Commonwealth.
We had that.
The jury had that. The Commonwealth's case was clearly focused on the neck until the moment when she testified, my breathing wasn't impeded, and that part of the case fell apart. I mean, that's the case they tried to put on. The fact that the jury had that, though, I don't think changes the focus of her testimony.
But if they can see in these photos, as I can see, marks on her neck, that's consistent with assault and battery.
If they can see, they can look at those, but the problem is we don't know that that's what they relied on. We don't know that they relied on that as opposed to her testimony about the chest. We don't know whether they just relied on Mr. Juden's testimony where he said, no, no, no to all the assault, but I grabbed at her and I scared her, which, you could use that to convict of an offensive battery. We just don't know what the jury relied on. And this was a jury, because, we can tell because of the not guilty, this was a jury that was carefully sifting the facts.
Could I ask you about offensive battery? How do you respond to the argument that if one element can be proven in 2 different ways, that doesn't preclude an offense from being a lesser included?
Right. So I think under, I tried not to get bogged down in this, but I think under...
I mean, the concept was quite confusing to me.
Yes.
I was hoping you could help me understand.
Sure. No, I think under Poro, this court is probably constrained to find that any intentional battery is a lesser included of strangulation. I think if you look, Poro relies in part on some cases where the SJC deviated strictly from an elements-based test. One of them is Santos. The SJC later overruled Santos in Anderson. This court in Brule has sort of done some trying to piece through those lines of cases. I think it's tricky, and I think under Poro, you probably do find that it is a lesser included, but that's why my focus is on the fact that I don't think that is dispositive to the major issues in this appeal, because you don't need to reach that. There isn't clear published case law on that. You don't need to reach that. And I would just briefly say, I do think this was highly prejudicial to my client because of the way it impacted the way he put on his case. His lawyer promised that he would testify and deny strangulation. We know that that kind of promise, if it's not fulfilled on its own, can be ineffective assistance of counsel. When the Commonwealth says in its brief that there was no impact, no prejudice to the defendant's defense, it ignores that promise wholesale, completely, just doesn't talk about it. The Commonwealth claims that the defense's trial strategy was focused on the neck. That's a bit misleading. They were focused on the neck during the Commonwealth direct case when the charge was strangulation. The closing does not focus on the neck. The closing is denying the assault completely. Everyone had to pivot when the case changed. And of course, the evidence changed after the fact. So decisions about how to cross-examine witnesses, decisions about how to object to evidence were all made with the understanding that the charge was focused on the neck. And so, there wasn't cross-examination on certain things. We don't know how it would have impacted, but I would say certainly that prejudiced my client in terms of his ability to put on his case and to put on a defense. This mid-case shift to a much broader and slightly different on offensive battery offense prejudiced him in his ability to pursue his claim, defend his claim. Thank you.
Thank you so much. Attorney Paris. Good morning.
Good morning. May it please the court, Molly Paris on behalf of the Commonwealth, asking that this court affirm the defendant's conviction. This case really comes down to whether simple assault and battery under an intentional theory is a lesser included of strangulation. And here in ruling...
Let's say it is, right? You have all of this evidence and closing argument, which is not evidence, and jury instructions about basically any place that she alleged he touched her on the body could constitute this crime. But to your sister's point, it was charged as a strangulation initially, which is the neck. So how do we know that the jury convicted him of the offense of touching to the neck as opposed to any other part of her body?
When you look at the evidence in the light most favorable, we have the pictures, which were the only photos admitted at trial, which show the neck. We have the officer's testimony, which...
Why would we look at the evidence in the light most favorable? It's not a sufficiency argument, right? The question is whether there's a substantial risk that the jury convicted the defendant of conduct that was not charged. You would agree that if there is a substantial risk that the jury convicted of one or the other, based on one of the other acts, that would be a variance or whatever the nomenclature is.
Yes, but I think here where the focus of the trial was the neck, and when we look at the jury instructions after the judge ruled on the defendant's motion for a required finding of not guilty, he specifically tells the jury, I'm withdrawing the charge of strangulation, count 2, and I'm reducing that to I'm reducing that to simple assault and battery. And again, the jury was only instructed under an intentional theory. So when we look at those instructions that he's telling the jury, look, up until this point, this case has been tried as a strangulation charge where the focus has been the neck, and now I'm withdrawing that charge and instructing you that, this is an assault and battery at this point.
But the judge doesn't limit the jury to considering just the touching of the neck.
Correct. Though the jury instructions were unobjected to, there was no supplemental.
Well, I mean, the instruction is correct insofar as it goes, but there was an objection to putting the charge before the jury at all, right? Because, I mean, it seems to me defense counsel pretty clearly said this isn't the case that he prepared for.
I understand, Your Honor. I read, looking at transcript page 139, when the judge says assault and battery is a lesser included of strangulation, and defense counsel objects to that. I read that as an objection as to reducing count 2 strangulation to the lesser included offense. And for that very reason, that's why in this case where there was never a motion to amend, regardless of what's on the docket, where there's no motion to amend, there was never any language or any moving to that effect in the transcript itself. And the whole purpose of that under Mass Rules of Criminal Procedure 4D is so that parties can object and be heard. And so what's borne out in the trial transcript is the defendant objecting to the judge's ruling that simple assault and battery is a lesser included of strangulation.
Okay, but that was at a point in the trial, and you've had an opportunity to look at the prosecutor's closing statement, correct?
Correct.
Do you see the concern if we're looking at substantial risk that the jury somehow considered evidence that it ought not to? That neither the judge nor the prosecutor, and I understand the case law of closing arguments aren't evidence, but gave a little bit of a wide berth for the jury to consider. I mean, I'm looking again at the closing argument by the prosecutor. They certainly don't limit the theory, the Commonwealth's case, to this.
The closing certainly wasn't a model of clarity, but again, I think when this court's looking at variance and considering the evidence and the jury instructions, also those jury instructions that were given partway through the trial when the judge ruled on the defendant's motion for a required finding, the jury knew that this touching was to the neck. And we can't get into the minds of the jurors, of course, but I think based on this record, there was a focus on the neck. The pictures were pretty prominently focused there. As to the officer's testimony that he observed red marks on the victim's neck that were consistent with strangulation. The victim's testimony, again, she's referencing chest and neck, but it's not necessarily a term of art. She's also, based on the trial transcript, describing to the jury, and we weren't in the room, as to where that touching was.
I don't know, it seems like there was a lot of testimony about him jumping on her and pushing her down, and limited testimony about touching of the neck. And following up on Justice Walsh's question, how do we get past the part of the closing where the prosecutor specifically references he proceeds to grab her phone and gets on top of her, and that's an assault and battery?
I mean, unfortunately, we're stuck with the record as what it is. The jury was instructed that closing arguments aren't evidence, as always. I don't believe there was any objection to the closing argument. That's not being challenged.
I mean, it's not, that's kind of not the problem. It's not the problem that the jury would consider that to be evidence, but rather that the jury at this point is not limited as to which act they could consider as the assault and battery, because the judge never limited them, and the closing certainly did not limit them.
I think just focusing on that, again, defense counsel, I think it would have been incumbent on him to have requested, maybe a specific jury instruction that, narrowed it in a little bit more. But again, this case was always about a harmful touching, and there was certainly evidence from which a jury could find that the harmful touching in this case was to the neck, where this was an unraveling, continuous course of conduct, where an all or nothing strategy where the defendant jumped on the victim and strangled her, and then where there was insufficient evidence as to the impaired breathing, the judge properly allowed the lesser included.
I know this isn't a sufficiency case, but if we were looking at this case through that lens, even the conduct for which he was found not guilty, the intimidation of a witness, and perhaps the jumping and grabbing the phone that perhaps was intimidation of a witness, but perhaps was also an assault and battery, could we consider that evidence when we're looking at the sufficiency of the assault and battery?
Whether he was acquitted.
Jumping on her, trying to grab the phone, that evidence, not having nothing to do with the neck.
I don't think so, and I think when you read the openings and the closing, the grabbing the phone was always connected to the witness intimidation. So I don't believe this court could.
So the jury comes back with a question, right? And they want to be re-instructed, and they send in the written instructions for both charges. That was another opportunity, right, for some form of an objection as to the assault and battery, and there was none made at that time, right?
Correct, as to the instructions, yes.
And then when the jury came back with the guilty on the A and B, could the defendant have done something at that point to clarify on what part of the body they determined there was an assault and battery? I mean, there wasn't a special jury verdict slip that picked out certain parts of the body.
Right. I think that would have been prejudicial, like listing out a menu of options as to this touching, and then asking the jury to not rely on their memory. I'm not quite sure. I didn't find a case specifically addressing that. so it's hard for me to answer. Unless the court has any further questions, I'd rest on my brief.
Well, I'm not trying to make your argument, but I'm just, again, looking at the closing statement was brief. And it does seem on the top of page 182 in the prosecutor's closing that he says, as a result of the defendant's jealousy, he proceeds to grab her phone that gets on top of her and uses force in both of his hands. And I would submit to you that that is assault and battery, and that has been contact. That has been constant. I mean, he does qualify the use of force in hands. So before, I think I'm probably just amending my own. Maybe it's not as wide open as the prosecutor in its closing that I originally had stated about the jumping on top. He does qualify of the hands and the use of force with his hands, but it's close.
That's correct, yeah, and I think that just goes back to my earlier point. It's just not a model of clarity, but.
Could I ask you
Stuck
about
with
the
that.
lesser included argument? If the jury had been charged only on offensive battery, would that be a lesser included of strangulation?
I don't believe it would, but I think.
So
when
why
you-
does it change? Because there are two different ways that the jury could have found battery as they were instructed. Because if they were instructed only on offensive battery, there would be an additional element, right?
There would be, and I don't know if it would be proper for the jury to only have been instructed on just an offensive battery. I think they can be instructed on the different theories of liability.
Well,
as to-
It's never proper to instruct just on offensive battery. If there's no evidence whatsoever of, say, an injury, you couldn't just instruct on offensive battery.
You could, though I didn't read the case law as requiring a harmful battery to require an injury.
Right, so let's say you have a case where there's plainly no evidence whatsoever of an injury. Could the judge instruct the jury only on offensive battery?
They could, depending on the
And in that
facts.
situation, would it be a lesser included of strangulation? I don't expect you
honestly
to,
have-
this concept is very confusing to me, as I said, so.
Yeah, I mean, I think I don't know if that would, I can only imagine a situation where a harmful battery is a lesser included of strangulation, only because I mean, it would always be an offensive touching, but where there's a harmful touching, we don't even look to consent.
Okay.
I'm not sure if that helps.
Thank you very much.
Thank you.
Very well argued case. Thank you both. It is now under advisement. Our next case is Commonwealth versus Fred Douglas Baskin, docket number 23P764. Good morning, Attorney Merrill.
Good morning, Your Honor. May it please the Court, I'm Dale Merrill, representing Frederick Baskin. While the Court may be feel they're obligated to follow such cases as Soto and Figuerello, these cases are in direct conflict with the United States Court when they talk in Gantt. They're very clear in Gantt. You can search to prevent from grabbing a weapon and for officer safety purposes, and it's not a search after the person is out of that space.
So I have a specific question for you about this. As you may know, I authored an opinion in October of 2024
Soto,
that
yes.
raised this exact question, and to my great surprise, the SJC denied FAR. So the law of Massachusetts is what the law of Massachusetts is.
And what I'm arguing, Your Honor, is that Massachusetts cannot give less protection than the Fourth Amendment gives, and that Gantt is a ruling case in that matter. We can also differentiate the facts in Soto, which you authored, Your
Either
Honor.
of you didn't submit a 16L on Soto, right?
Pardon me, Your Honor?
You didn't submit a 16L on Soto. You did not submit a 16L letter on Soto, did you?
Yes, I did.
Geez, we did not receive it. I apologize. I will ask our clerk's office.
Okay. I mean, in Soto, you have a situation where you have, under video surveillance, somebody is at that moment watching what's happening in their home and telling the police, there's two people in my house, and they have guns, and there's a backpack, and he's describing the entire situation. And when the police arrive, you have one of the defendants turning in and saying, the stuff is in the backpack. That's a very different kind of fact pattern than what...
Except that in that case, similar to here, the argument is he couldn't reach the backpack. He was surrounded by police. One of the suspects was handcuffed. There were a ton of police officers. They were at gunpoint. He could not reach the backpack.
Correct. He could not reach the backpack. And I would argue that in both cases, there should have been a search warrant issued, because the issue is for the search at that point for a weapon is to protect officer safety. The search for evidence of the crime for which the person is under arrest is a very important distinction here, because in Soto, you knew what the person had just been doing. You know they'd been robbing the house. In the case with...
So you think the time makes this case different?
The timing makes it very different. But with Mr. Baskin's case, you have a situation where you had no idea it's 9 days later versus immediately happening, and that's a very critical fact. And with Mr. Baskin's case, you have absolutely no idea that there's any evidence that's going to be found whatsoever, because the complainant had never said that there was her material, any of her stuff was missing. She never talked about her mail being missing, any clothes, and identification.
What about the knife?
Pardon me?
What about the knife?
The knife was an issue that did belong to Mr. Baskin. And the Commonwealth actually makes a big issue about the whole issue of durability and so forth. The issue is whether the item is durable to the person themselves at that point. And we need to look at all the other stuff. The knife is a very general thing. Anybody can have a knife. It's pretty innocuous in terms of evidentiary value. What's really important to look at is all the evidence that was seized, such as her identification like that, which was not durable to Mr. Baskin. Therefore, this is evidence that they would have made a big difference in this case. Had that evidence been suppressed, her identification, her cell phone, items like that from the backpack, then that would have made a difference in the case, because...
Before we get to prejudice...
Pardon me?
Before we get to the prejudice of what was inside of the backpack, it seems to me that the case rises or falls on whether the police could open that backpack without a warrant as a search incident to arrest. And I hear you in disagreeing with the underpinnings of Soto, that under the federal Constitution, it can't happen, that Gantt controls, right? So
yes.
you, one, disagree, and then two, you differentiate the facts. So,
yes.
But philosophically, right, you disagree with the ability of an officer to arrest first and search after. But the case law appears to allow that very thing that you're arguing with us about. The case law, apart from the situation of is it real time, is it a gun, etc., supports the proposition and endorses the belief that we don't tell police officers to put themselves in harm's way, open up something that they may be able to open up because they have probable cause to believe that evidence of a crime is there, and then arrest. So versus safety of the officer, probable cause to believe that there's evidence of a crime, even when someone can't get to it, their hands are cuffed, they're outnumbered.
Right, but there was no reason to think there would be evidence of that crime 9 days later. It's also important to focus on the fact that Gann also cautions against a reading of Belton that would allow you to reorder that. And if you look at Shamil, they say that this is not
Right, read them all.
This is a
Case law right now that we are required to follow is Soto.
I understand.
And so when I look to differentiate, because let's face it, that's the case law. You respectfully think that the Chief Justice got it wrong, okay? That's fine, that's fair.
You won't be the first.
Okay? But when I look at the state of the law and I look at the facts of this case, I also see that this was something that was actually attached to the defendant's body versus in Soto where it wasn't. It was in the hallway, right? The body is there, the person's cuffed, it's over here. It's right on his physical body. On top of it, when we talk about whether this case can be differentiated, and I want you to please respond. This is the problems that I see are that there was evidence which I think can be considered that he was known to carry a knife and that upon being placed under arrest, he put up a fight. And so when we talk about split-second decisions and being on his body, having this information about a knife, in some ways, it's a tougher case to differentiate than Soto, where person's flat on the ground and the backpack is not within his wingspan, right?
Sure, but it was taken off of his back, and at that point, there's no chance of him reaching for a weapon in it. So there isn't a question of officer safety at that point. When we get to the police station...
Just officer safety in mind is what I'm trying to express to you. Is that
when we get to the police station, the policy, the stated policy was that they were supposed to, if an item was sealed like a backpack, to put it aside, inventory it as one item, a backpack, and then go get a search warrant for the contents, and they failed to do that.
inventory right now. We're
Pardon me?
talking about a search incident to arrest,
Yes.
and they open the backpack. Let's for a moment not address the inventory search.
I would argue that once that backpack is not something that the person can grab at the point that
I understand.
he is being arrested, that they need to go get a search warrant. And since at that point they had removed the backpack from him, he could not reach that backpack at the time the search was being conducted. Therefore, I would argue that a search warrant was needed for that.
I understand. Thank you.
What about the second rationale for search incident to arrest? So they knew that, the officers knew that a knife had been used in the attack. They knew he was known to carry a knife. So why isn't there reason to believe there would be evidence of the crime in the backpack?
You know, knives are something that are very common items. This is not, and the case law actually talks about, these items which are very common utility that many people could have. I don't think there's anything specific to it.
Well, I mean, I'm not sure it's so common to always be carrying.
Pardon me?
I'm not sure it's so common to be always carrying a knife on your person. Why couldn't they believe it was the same
you and I
knife
may
used
not,
in
but
the attack?
It's something that I guess many people do.
But why isn't there probable cause to believe it was the same knife that was used in the attack a few days before, and he might be carrying it on
Well,
his
there's no
person?
specific description of what the knife looks
But
like
this
for.
is
they're
probable
looking
cause,
for.
right? In Williams,
And the case really doesn't rise and fall on the knife, because the case really rises and falls on the other evidence that was found in the backpack, because the girl had two stories. First, she said it wasn't him, and she didn't know who it was, and then she comes up several days later with a second story blaming him.
The question is whether, under the second rationale for search incident to arrest, whether there was probable cause to believe there was evidence relevant to the crime in the backpack. So I want you to focus on the
But the
knife.
knife wouldn't necessarily be specific to evidence of this crime, because he could have been carrying any knife. He could have been carrying, any knife, not necessarily a knife specific to that crime. There's nothing to say that he's carrying a knife specific to that crime at that point.
Could I ask you about the inventory policy?
Pardon me?
The inventory policy of the state police.
Yes.
It says, any person who comes into the custody of the department shall be searched.
Correct.
So why wasn't it inevitable that they would discover the items in the backpack?
They would have had to have gotten a search warrant, and I don't think there was probable cause to go get a search warrant.
Why would you need a search warrant to do an inventory?
Backpack,
To do an
because they're-
inventory search?
The inventory policy says that they're going to take a sealed item like a backpack and put it aside, inventory it as a backpack, and then go get a search warrant. I don't believe there was evidence sufficient for probable cause to go get a search warrant because they didn't know that any of the girls' items were missing. And searching for a knife, which is a very general item, would not have been sufficient. You know, we have reason to think he committed an offense with a knife. He may have a knife with him. It's 9 days later. You know, that's not really going to carry the case. What made a difference in the case was the admission of the girls' personal items, which the police didn't know existed. Therefore, they couldn't have put it into a search warrant to say that those items were missing.
So the inventory search is an exception to the search warrant.
Pardon me?
An inventory search, as long as there's a clearly written, defined inventory policy by a police department, is an exception to the search warrant requirement.
Correct,
And it's
but
based upon protecting a person in custody's property. And so I don't know that you sufficiently answered why it wasn't inevitable that a person who is in custody wouldn't have their items.
because the policy also the written policy also specifically says they're going to get a search warrant, and they would not have had probable cause to go get a search warrant. So this search is really a go-around to evade the issue of needing to get a search warrant, because they wouldn't have had the evidence they wouldn't have had the factual basis to put behind a search warrant.
Where does it say you need a search warrant? It says search warrant for locked containers.
Pardon me?
It says you need a search warrant for locked containers. It doesn't say you need a search warrant. It says any closed, unlocked container shall be opened, and each article inventoried individually.
It said that it says that the backpack should have been itemized as a backpack, and then the search warrant obtained.
Well, isn't it a closed, unlocked container?
And the backpack was a closed container.
Unlocked, right? And it
It
says
was
it
locked.
shall
It
be...
was sealed. It was sealed. It was closed. It was a closed
Okay,
container.
but it's not locked, right? Was the backpack locked or
I
not
don't
locked?
believe it had a lock on it, but it was closed.
And it says any unlocked container shall be opened and each article inventoried individually. So that says you don't need a warrant to open the backpack.
The way I interpreted that, and the way my memory is that it would have required a search warrant for the backpack.
Just like a pocketbook? Just because-
Pardon me?
Think of a pocketbook, right?
Yes.
You don't lock a pocketbook. Do you disagree that an inventory search can't unzip the pocketbook and protect the contents by inventorying the contents of how much money is in there, what other items, car keys, et cetera?
The way the policy, the way I read the policy, it would have required a search warrant. But that's my memory of it.
Understand.
If there's no further questions, then I'll rest on my brief.
Thank you very much. Attorney Mello.
Thank you. May it please the court, Emily Mello on behalf of the Commonwealth. And I will just note at the outset that I did, in fact, receive Attorney Merrill's 16L letter
Thank you.
regarding Commonwealth v. Soto. And I do think that Commonwealth v. Soto, which came out several days after I filed my brief, is really on point in this particular case. I think that as far as a search incident to arrest, the police can do a search in order to prevent the suspect from accessing any type of weapon, and that is set out in Figueroa, in Neto, and again in Soto. And I do think that it is distinguishable from Gantz, in which they were arresting the defendant for a motor vehicle charge, and once he was already 12 feet away from the car, handcuffed and I believe seated in the police cruiser, they then went back to the car and did an exploratory search and found some drugs in a pocket of his jacket. That's a completely different situation. Here we have this team of police officers going to arrest this defendant. There's a warrant out for him. It is a violent assault. He is known to carry a knife. He's known to have a history of assaultive behavior towards women and towards police officers. When they get there, he does in fact resist, and they have to take him to the ground, all while he is still wearing the backpack. So then they...
Why are those facts relevant insofar as a search incident to arrest is concerned? Isn't at least under federal law, this search can be automatic, right? Anything within your wingspan is automatic. It doesn't even matter whether it was a violent crime or not. Once you're arrested, they can search within the wingspan, right?
For possible evidence of a crime, there are two justifications. One would be the concern for safety, and the other would be...
But the concern for safety automatically applies to anything within the wingspan of the person being arrested.
Yes, Your Honor, I would agree with that.
Right, so it doesn't even matter whether there were facts showing he was dangerous, because that could justify a search on a different ground. But once you're arrested, that you're entitled to search within the wingspan, right?
I would agree that you are entitled to search within the wingspan.
Is it your position that Gantt is limited to automobile searches?
I don't think that the Supreme Court has specifically limited it to automobile searches. I would be interested to see if they did, if another case sort of came up, because it's interesting how, they had their ruling in Chimmel, and then they sort of expanded it to automobiles in Belton. And then in Gantt, I don't think that they really contemplated the situation that we're looking at in Figueroa and Soto, and in this case, where you have a defendant who is wearing a backpack, who's taken to the ground. At that point, I don't think that the Gantt court contemplated that you were supposed to open the backpack while he's still flailing on the ground and then handcuff him. It just doesn't really make a lot of sense from a logical standpoint. So I think it's really different from the situation in Gantt, and like Your Honor pointed out, I would be interested to see if that is confined to an automobile context. In any event, they also did have probable cause to look in the backpack for that knife, and they were aware that the defendant had taken the victim's cell phone. So I think that both of those items are durable. This is only 8 days later. This isn't months later, even though there have been cases where months later the searches have been upheld. This is only 8 days. There's no reason, and there was no reason to think that he knew that the police were looking for him. He had told the victim, tell the police you were jumped, and she did initially do that. And he was not aware that once she was in the safety of a women's shelter, she then revealed what had actually happened. So there was certainly probable cause to believe that he would have that knife or that cell phone on him at the time.
Why would he be carrying the cell phone around with him?
I think that the durability of the item and the fact that I just want to go off of only the information that the police actually had at that time, and the information that they had at that time was that he had taken her cell phone. I mean, cell phones are generally something that people carry around with them. I do think that there was, at a probable cause standard, the ability to look in that backpack for the cell phone. I would disagree with the motion judge on that point. He found that there was only probable cause to look for the knife, but in any event, probable cause for the knife. As far as the inventory search, I would just point to...
And you say that's only relevant to the armed robbery charge?
I think that if the court were to find that the search was improper, I think that as to the other charges, given the overwhelming evidence, it would be harmless beyond a reasonable doubt.
Okay.
And I'm happy to go through the facts, but I think the court is probably aware of them. As to the inventory policy, I would just point to my supplemental record, page 5. That is the portion of the inventory policy, which I believe was read out in court before, about the fact that the police shall inventory the items within an unlocked closed container. A backpack would fall into that category, so I would disagree with the motion judge on that point as well.
So this policy would apply even though they were intending to transfer him to the Danvers Police Department?
That's correct. The subjective intent of the police officers does not control.
And that's because he was plainly in custody of the state police at the time?
That's correct.
So do you have any insight as to why we don't have a witness from the Danvers Police Department
I do not have any.
I'm assuming they
insight
did an
into that.
inventory search there, right?
That's outside the record, so I would not comment on that. However, I would say that it was in line with the state police inventory policy, despite whether the trooper testified that he believed it was an inventory search or not. It was in fact in line with that policy. And like I said, in any event, it was a proper search incident to arrest. And if there are no further questions, I would rest on my brief.
Thank you very much. The case is
Thank
under
you.
advisement. Thank you both. Our next case is Commonwealth versus Hector, Heredia-ALAMO, docket number 24P354. I remind counsel this case is partially impounded, so please do not use the victim's name. Mr. Benyon, good morning.
Good morning to the Chief Justice, and may it please the Court. In criminal law, rape victims are often required to testify with particularity about penetration because penetration is an essential element of the crime. This requirement stems from several legal principles, which I'll go over, but the main point here is that we're looking to distinguish rape as to something else that could have occurred. So, for example, he was also charged with indecent assault and battery. That's a lesser included offense of rape. And so to define the crime, we need to pin down penetration. In this case, the language used was general. It invited the jury to make a leap of faith or infer what actually occurred. Under principles of due process, this is a problem because the government needs to prove beyond a reasonable doubt that element occurred. And in this case, you don't have that. Now, I know this was discussed at the motion for required finding. You're in as good a position as the trial judge to look at this. And the general language here.
She actually directed out a number of indictments, didn't she? The trial judge?
Yes.
So I would agree with you that the prosecution could have done a much better job on this question that you've raised. But I guess my question for you is, if you would agree with me, I think, that circumstantial evidence is enough.
Yes, circumstantial evidence is enough.
So I want to give you a couple of pieces and ask you why, with this evidence, it's not sufficient. So she testifies, I'm just looking for the site of the record. I think it's in transcript 3, page 53, that she could not remember if the defendant, quote, ever put his finger in her front private. So we have some testimony about her front private, which is the problem language, in my view, in this case. And this testimony is not the evidence for the ultimate conviction, but we have her referring to her front private and testimony that he didn't put his finger in her front private. We have her testimony that she refers to that area also as her cookie, and there's some evidence about that being her front private. And then there's the evidence, as you've pointed out, that she says he, quote, licked her front private. why taking those three pieces of testimony together don't we have sufficiency? I understand in isolation.
So, with respect to cookie, it's still as general a term as can be applied.
I'm talking
What
in
you-
isolation,
know.
I agree with you.
No,
Put them
but
together for me.
But taken together, you're still asking the jury to make a leap because you don't know what she subjectively means when she says cookie or her front private.
But if she says he didn't put his finger in my front private for another situation, why can't the jury infer from that that when she said he licked her front private, it wasn't the same body part, that is something that could be penetrated?
So again, you're putting the emphasis on the word in, which I think leads you to penetration. And that's, again, problematic because, again, proof beyond a reasonable doubt is supposed to be a high bar precisely to prevent the government from taking away someone's liberty interest.
Absolutely, but on a sufficiency, we're looking at it in the light most favorable to the government.
Even in the light most favorable to the government, though, you have to look at her testimony. In cases like this, one of the reasons we need to be so careful is because this is so inflammatory and it invites the jury to find guilt, not based on proof beyond a reasonable doubt, but in an effort to just make sure that whatever occurred, he doesn't go free. But nonetheless, under the standards of the law, penetration is the element. And if it's not met, then it could be something lesser included or it would be a lesser verdict. In this case, there are two claims of indecent assault and battery that I'm not touching. But to have that be so general is a problem, especially, and this is the part that I want you to focus on, a 14-year-old girl. In cases, and I've tried it in the parentheticals in my brief to show you kind of different language that's been drawn out, even when you have a very young child, conceding the fact that, a child witness does not need to go into testimony as to biology or particular points, but the one point that all young children can get, and this is what most district attorneys use to bring this out, is a touch was made where you urinate or where you pee. This is a 14-year-old young...
No, I disagree with that.
In what sense?
Well, in a lot, in its entirety, basically. So you're suggesting to us that the case law only supports a conviction, and even on the sufficiency, the prosecutor has to show that the touching was in the area where a person pees, right? I think that's wrong as a matter of law. So oral sex, right? And the area, not to be like an 8th grade biology class here, but have you taken a look at the cases that say what can be established if the defendant comes in contact with the victim's vagina, with the vulva, the labia? I mean,
So in this case, none of those terms were used, and but the problem is I guess in the most general sense, even for young people, the entire pubic area could be viewed as the front private. And while that, depending on where a touch occurs on the pubic area, it might connote penetration, or it just might be an indecent assault and battery, which is still a crime.
not limited, though, to what you were suggesting earlier. So I don't want to put a burden on the Commonwealth that they don't own, right? I wouldn't.
Agreed, but again, on the one hand, you have, and I don't think the case law has been a model of clarity with respect to this, but I think the general principles that I've pulled from the cases and that I've cited is that with the younger victims, there's more leeway to allow more general language, but in the cases that I've seen, to connote penetration as opposed to some other area of the pubic area, where you pee kind of pinpoints that area. Now, I understand that...
Do you have a case to cite that proposition? Because I have not found one.
Well, in my brief, in the parenthetical, there are cases where that was the language that the court used to allow.
I'm not suggesting that couldn't form the basis
Yeah.
of a conviction.
I'm
What
not saying that-
suggesting to you is that you have a case that says it's limited to the Commonwealth having to show.
Oh, no. What I'm trying to show is that this could have just been an indecent assault and battery. What we don't have is information that pins down penetration, which is one of the elements that is required, the government is required to prove. And what we don't want is the government giving such general language that the jury can then infer a crime where a crime hasn't been proven. Because again, in this, it's...
I think that's where they're respectfully, that I think that the case law says something different.
Well, the cases are numerous that I've cited. Again, this is a 14-year-old girl. More could have been done. I think this is just a question of the government not preparing their witness well, and certainly not directing their testimony. It wouldn't have taken much more to show penetration, I think, with a witness like this, but they didn't even try. And that's what the problem here is. It allows the jury to just make that leap.
So in your brief, and rightfully so, you acknowledge that under Donlan, to prove penetration, the Commonwealth must show that the defendant touched or came in contact with and the various specifics of the body.
Yes.
If the jury believed that the front private was her vagina, licked is certainly touched or came in contact with.
If that's the case, yes. The problem is
I just want to make sure I understand the argument.
we don't know what she subjectively thought her front private encompassed. Now,
But
everybody wants to infer.
He did contrast this incident with when she said he didn't put something in it. So when you
Again-
bring them together to try to figure out what the jury had for evidence, and they had that the front private was something that something could have gone into. It didn't, but he licked it.
Again, the word
Because
in.
you make the argument front private could have been her breasts. If we're talking about something not going in it, that's not your breast.
Again, but she could mean like her pelvic region. Any place that's covered by pubic hair could be her front private. You just don't know what she thinks that means.
How do you reconcile that with, he didn't put it in my front private?
Again, so much emphasis is being put on the word in.
Because that's her testimony.
It is, but you don't know what she means by it. You don't, again, these cases are difficult because they invoke such passion, especially among lay jurors, and that's the problem. Proof beyond a reasonable doubt has to mean a high bar.
Right, but we're talking about sufficiency of the evidence. And so when you look at those three statements that the chief has identified in the transcript, you still say it was insufficient as a matter of law.
I do.
Okay. And so what more in order, so if the bar is low, sufficiency, and you say they haven't been able to get over it, what one thing needed to be added?
Again, there's no silver bullet. I mean, you can look at the case law that shows kind of how different assistant district attorneys have brought this out, but it wouldn't have taken much. I mean, again, it's the difference between an indecent assault and battery versus a rape. The consequences are more severe for rape. It's a higher penalty. And this does raise due process concerns, even though it's a sufficiency, because if the government doesn't prove that case,
Well,
they
does her
shouldn't get the...
testimony suffice to prove indecent A and B? This testimony, not the other indecent A and Bs.
This testimony, yeah, I think generally, as I look at the case law, I think it would. Sure it would. But again, rape is different.
Absolutely.
Now, I'll just finish this with the last point, and I'll quote Blackstone. It is better that 10 guilty men go free than one innocent man go to jail. I'm not saying that my client is completely innocent of everything, but he very well should be looked at as innocent for rape on this evidence. Thank you.
Thank you, Mr. Benyon. Mr. Baker?
Good morning. May it please the court. Assistant District Attorney Lee Baker for the Commonwealth. So I guess I have to say that all of this controversy is really controlled by a single legal proposition from Manas and then reiterated in King. We do not require victims to describe with scientific accuracy parts of their anatomy, or for children to possess vocabulary and habits of precision that many adults do not command. And what I would suggest—
I don't think even Mr. Benyon would disagree with that, but my question is, the prosecutor could have, I get that it's a 14-year-old victim of sexual assault. We all understand that. But prosecutor could have done a little bit of a better job tying this together.
Well, sure. But the issue here is not whether this prosecutor did as good a job as we would expect or other prosecutors. It's
I
simply
laid out
whether
3
this
pieces of evidence that
Yes.
I asked, is that sufficient? And that is when she says he didn't put his finger in her front private.
Right.
She refers to it as her cookie, and
Right.
that here he licked her front private.
Right.
Are those the 3 pieces of evidence that you say suffice? Is there something I'm missing?
I would say those 3 pieces of evidence, and I would add also to that, when I was reviewing the record yesterday, there's testimony about how he would touch her front private part, and that he told her that in the future she should wear looser underwear so he had easier access. And she testified that she did the opposite. She wore really tight underwear so it would be more difficult for him to access her front private part. Now, if the front private part that she was referring to is the mons pubis, as my brother would suggest is a possibility, I think that testimony also eliminates that. So I think that when you look
Happen
into—
to have a record site for that?
Yeah, let me see here. I actually make reference to it in my brief in the facts section.
I found it.
Thank you.
It's at jury trial day 4.
That's right. And so I would say that taking all of that together, that is sufficient circumstantial evidence of penetration. And I did focus on that comment about using scientific precision because I would suggest to you that based on people's common sense and life experience, one does not normally think of the mons pubis as part of a woman's genitalia. Like if you were speaking and saying your front private part, you certainly wouldn't be referring to that. That's a gynecological kind of classification. It's not part of commonsensical kind of talk. I would also suggest—
But if he had touched that area, that would be an indecent A and B.
I would say so, sure.
So I read your brief to be saying that if he had touched that area, that would be sufficient to support the rape, but now I hear you saying the opposite.
Well, no. What I'm saying, it would support an indecent.
But it would not
yes,
support the rape.
But it would what the case law says is that any intrusion, however slight, and it defines the labia, both internal and exterior, as well as the vulva. Now, when I was not familiar with the term mons pubis, so when I looked it up, the mons pubis is understood to be a part of the greater area, right?
Can
of
we
the
read the
vulva.
cases to be supporting a holding with that amount of anatomical precision?
No.
Okay.
because they don't need to, right? They don't go there to that. We have to start looking in anatomy books before we start thinking about that kind of thing. And so I think that it's very commonsensical. The circumstantial evidence supports it. I would also note that King is helpful here. In King, this issue arose, and they quoted Manes, and the facts of King were that the defendant had taken toothpaste, and he put toothpaste on his penis, and he told the victim to lick the toothpaste off, and she testified to having done that. Now, the question was, there was no testimony from the victim that his penis actually entered her mouth. And the court said it was enough. Her testimony was enough. They quoted Manes, and they cautioned they weren't getting rid of the penetration requirement, but they thought on those facts that was enough, right? And they didn't really articulate why that's enough, but I would suggest that sort of implicit in that argument is that she described a sex act, fellatio, that the jurors are familiar with. She described aspects of it. She didn't get to the final aspect of actually testifying to the penis penetrating her mouth.
But
right?
isn't it inferential the way it is here?
Right. And so what I'm saying is that when someone describes, this is in a sexual context, right? And what we know about basic human sexuality, just in our common sense and life experience, if someone is saying that another person licked their front private, these are not two equally supported propositions. The first thing that most people would think is that what is being described is cunnilingus. They wouldn't think that the person had licked their belly button. Now, under my brother's construction, that would be a possibility. Only in the minds of a gynecologist, much detached from normal, everyday human experience and human
It's a
sexuality.
little bit curious to me that the jury acquitted on the other count of rape. So she referred to that area as her back private.
Right.
And the jury acquitted. Doesn't that indicate they had some doubt about the element of penetration?
Yes, sure, on that particular count. But I don't think that they did on the count he was convicted on because of the difference in the nature of the sex act. Not to get overly graphic, but with anal intercourse, the case law is clear that if there wasn't some slight penetration of the anus, then that's not sufficient. With cunnilingus, it's any intrusion whatsoever. So if it's at the outer labia, the vulva itself, all of that would constitute penetration for that charge. So factually, they're very sort of different, and I think that explains the difference in the outcome. If there are no questions, I'll rest on my brief.
I don't see any additional questions. We will take the matter under advisement. Thank you both.
Thank you.
The court is going to take its morning recess, which will be about 10 minutes. When we return, we will start with the case of Susan Anderson versus the Commonwealth. Chief Smith.
Court is open, please be seated.
Good morning again. Our next case on the list is Major Susan Anderson and another versus Commonwealth of Massachusetts and others, docket number 24P552. Attorney Burke.
Good morning, Chief Justice Blake. Good morning, Chief Justice Shin and Justice Walsh. I'm here representing Susan Anderson, who, as you know, is a major in the state police. The issue essentially evolves around the department that she worked for and who she was under orders to comply with has refused to indemnify her for the issues of her defense in the state ethics case. I'm sure you're familiar with the circumstances of the case, but it bears importance to know that she was operating on duty in compliance with an order given to her by her superintendent. Her involvement in the case itself was so very limited. All she did was go to the individual, the officer who had put the so-called salacious materials in this.
Can I interrupt for a moment?
Sure.
Because our analysis really doesn't depend, as unfair as this and harsh as this may seem, as to whether the individual violated ethics, didn't violate ethics, followed a chain of command, is sympathetic, and just did what was being told in the paramilitary. I get all of that, but in the end of the day, sorry to say, it doesn't matter, right? Right?
What does matter?
What matters, right,
Yeah.
is that it's an ethics violation or a claim of an ethics violation versus a tort or civil rights, right?
Well, yes, I think it's all encompassed within the rulings of both Mameron and Pinshaw. And our interpretation of those cases requires the Department of State Police to have performed their responsibility under that Chapter 9A, to have indemnified her, to at least have defended her, not just from the two civil rights cases that she was charged with as a result of this, but also the additional case that was brought by, the action that was brought against her by the State Ethics Commission.
You raised this argument about duty to defend in your summary judgment motion?
We did, but the
summary judgment motion's not in the record appendix, so I don't know if it's raised there, but the judge didn't address it.
I looked at the number of times that Mameron, which I believe is the controlling case here, in the summary judgment argument, I think there's 4 or 5 references to Mameron, which obviously the Commonwealth should have been aware of.
The judge plainly wasn't aware that there was any argument about duty to defend being raised, because it's not in the decision.
I disagree. We clearly mentioned and pointed out the requirements of Mameron and pointed out the facts in Mameron, which involved an individual who had pled guilty to 2 criminal offenses, who had actually then sought indemnification, and Mameron specifically said it made no difference whether or not there were pending criminal charges or he had pled guilty or that he was in violation of the department's regulations. They had an obligation from the beginning to defend him, and that's what part of the argument was that the Superior Court conflated the duty of defense with the obligation to indemnify.
Did your client ask for a defense? At the time that the State Ethics Commission issued the order to show cause, did she ask for a defense?
Clearly. I sent a letter drafted to the then Colonel of the State Police. I believe it's an exhibit. She was notified of the show cause order on June 24th, 2020. I sent a letter to Colonel Mason 2 days later requesting indemnification under both 258-9A and relevant
No,
others.
not indemnification, a defense.
Well, and the defense is incorporated within this statutory framework of indemnification. The defense is...
I read your brief to be arguing mostly that there was a duty to defend that arose when the commission issued an order to show cause, and that the defendants were required to defend under a reservation of rights.
Yes.
That presupposes that your client asked for a defense back when the order to show cause issued. Where is the evidence of that?
It's in the letter. It's dated June 26th. I believe it's an exhibit within the record. I can
And
supplement, if it's not incorporated within it, I can supplement with the court's permission that was sent. In addition to that, we had requested an earlier indemnification request to the court when she had the two federal civil rights cases brought against her.
Okay, so let's assume the argument's preserved. In both Mamoran and Pinshaw, there is no question that the action at issue was a civil, in one case, I believe, is a civil rights action, and the other, it was a intentional torts action. That still raises the question of whether the statute covers either a defense or an indemnification for an ethics complaint.
If you look at Chapter 258-9A, the language begins by saying that in the event a suit is filed, there begins a requirement, a duty to defend. If you look at the second paragraph, it then goes on to say that there is a continuing obligation for them.
You're leaving out the second part of the paragraph, the first paragraph. If in the event a suit is commenced by reason of a claim for damages resulting from an alleged intentional tort.
Correct.
Or by reason of an alleged civil rights violation. In Pinshaw and Mamoran, there is no question that statutory language was met. But here, I'm having trouble seeing how an order to show cause issued by an ethics commission, the Ethics Commission, is a claim for damages resulting from an intentional tort or a civil rights violation.
If you looked at the second paragraph,
Yep.
it goes on to state, the Commonwealth shall indemnify members of the state police or an employee represented by State Bargaining Unit 5, including but not limited to legal fees and cost of any in an amount not to exceed $1 million arising out of any claim, action, award, compromise, or settlement. This case, the state ethics case, clearly arose from the initiation of the two civil rights cases that she was indemnified for.
It says a loss arising out of any, we'll just focus on action, resulting from any alleged intentional tort or an alleged civil rights violation. The Ethics Commission, I don't think, is concerned with whether your client committed an intentional tort or a civil rights violation. They're concerned with whether she committed an ethics violation.
But, Your Honor, it wrote the Ethics Commission case, it wrote the action, which is what they refer to it themselves. If you look at 268-2, they define their cases as actions. This statute says if it arises out of a civil rights case, and that's what it was, the same predicate factors and basis for the initiation of the civil rights cases that were brought against her were the same predicate factual basis for the State Ethics Commission. After the civil rights cases were dismissed, the Attorney General's office then investigated to see if there was criminal conduct. They exonerated my client as well as the other individuals and said there was no criminal conduct. That also created a conflict of interest which prevented her from being represented by the Attorney General's office. After the Attorney General's office issued their declaration that there was no criminal conduct, they then referred the same case, the same factual basis, to the State Ethics Commission to do their investigation. It clearly arose from and was factually predicated upon the same facts that gave rise to the claims for those two civil rights cases that were ultimately dismissed. The Ethics Commission case, the action, was part and parcel of the same basis of the entire investigation that went on as a result of this case. And the issue here, and under Mamoran, is that the Commonwealth had an absolute duty to defend her, whether they agreed ultimately or not to indemnify her. They had an absolute duty from the initiation of that State Ethics Commission claim to defend her. And if you look at Mamoran and the language in both Mamoran and Pinshaw, it says it matters not whether there was criminal conduct, which there clearly wasn't here. She's ultimately exonerated. You have an individual who was acting at the direction of her employers. She's acting within the scope of her employment, doing nothing that's illegal other than what she's required to do. Their refusal not to indemnify her is clearly in violation of Mamoran and Pinshaw. And what's important, if you look at Pinshaw, footnote number 10, the state police didn't have any authority to make an administrative decision not to indemnify her. In point of fact, Your Honor, what they did was they usurped the judiciary's responsibility to make that determination. And look at Pinshaw, footnote 10. They didn't have any ability or right to determine that she was not entitled to a defense. They had an obligation to do so. They didn't do so. And that's the basis for our claim here. And she has had to pay for her own defense for the last 6-7 years now as a consequence of their failure to comply with Mamoran and Pinshaw. There is a direct nexus between the factual basis for the civil rights cases and what flowed from that in both the Attorney General's office referral to the State Ethics Commission. If you look at what the Commonwealth says and what they relied and the Superior Court relied upon was the case of Triplett. And Triplett first of all, Triplett was a criminal. He had criminal convictions that were involved in addition to the state ethics claims. The court refused to indemnify. And if you look at a careful analysis of the two statutes, he was a municipal officer, and there's a very limiting amount of items in section 250, chapter 258, section 13. Municipal officers are only indemnified for any claims, demands, suits, or judgments. It differs significantly because 9A says they're entitled to indemnification for any claim, action, which this was, award, compromise, settlement, or judgment. So if you look at the difference between those two statutes in statutory construction, you can't just ignore the fact that the action rather, is added into Section 9 that doesn't appear.
Section 13 is considerably broader than Section 9A in the sense that it contains no limitation as to claims for intentional torts or civil rights violation. It doesn't say anything about that.
I see it just the opposite, Judge. I see the fact that they have an action in 9A, which doesn't say a civil action. If the legislature had said you have to have a civil action to be indemnified, then that would be very limiting. But the fact that they've added an action to this broadens it, it doesn't limit it.
You have to agree that Section 13 contains no reference to an intentional tort or alleged violation of civil rights. Correct?
I don't agree with that.
Well, that's what the statute says. It does not have any limitation, Section 13, to a claim, whatever the language that's used, arising out of an intentional tort or a civil rights violation.
I would interpret it just the opposite, most respectfully, Your Honor. Because when you add, the very reason that they're adding an additional category and not limiting by saying a civil action broadens it to conclude any action.
But you're asking us to read words in and out of the statute. You know we can't do that.
You're not, no, it's, if you look at 258-9A, it says they are entitled to indemnification for any action arising out of a civil rights complaint made against them. And that is something that is not in Section 13, but it is in Section 9A. And if you look
I think that's what Justice
And
Shin
Section
asked
13 does not say indemnification is limited to intentional torts or civil rights violation. I'm looking at the statutes right in front of me.
Okay, I'm not disagreeing with you. I'm saying that the fact that it says that there is any action that is referenced in 9A broadens the scope of that to include the State Ethics Commission action that was brought against my client. I believe she is entitled to the benefit of being, and again, it's not simply reading something into the statute. This is a person who is acting within scope of employment. This is somebody who is acting in accordance with what her instructions were from her supervisor. She doesn't have any ability to do anything other than what she's ordered to do. And she is entitled to be defended from the beginning from this case. And if there's a dispute over that, it had to have gone to a court for determination as opposed to the department making the independent assessment as to what their obligation was.
It looks like we have reached your time, but let me make sure there's no other questions from the panel. Seeing none, we'll take the rest of your arguments on your brief. Thank you very much. Attorney Brunelli?
Good morning. May it please the Court, Dan Brunelli, Staff Counsel for the Department of State Police, representing the appellees. I would respectfully request this Court to affirm the order of the summary judgment by Superior Court, as there was no error of law.
For the conflict of interest, right, because one agency is looking at it from another agency, would she have otherwise been entitled to indemnification?
As it relates to are you referring to the ethics charges? I would say no, based on the plain language of the statute. And to be clear on the record, because this was requested, to break it up, there was a civil rights lawsuit filed in federal court in 2017. Page 125 of the record shows that Major Anderson was indemnified for that. Page 149 of the record shows 3 years later, in 2020, there's a request not for a duty to defend, but a request for indemnification related to an Ethics Commission charge.
Resulting from the AGO referral.
Correct. And so my analysis would be is that if the court is to adopt the appellant's argument that if you have an incident, and as a result of that incident, a civil lawsuit for intentional torts or violation of civil rights branches off of that, then under their analysis, any other action that branches off that incident has to be covered as well under 9A because a civil right lawsuit stemmed from it. And I would suggest that's an expansion of the statute, not based on the plain language, the intent of the legislature when they created 258A, 258, as well as Triplet, Marimon, and Pinshaw. And I won't go into detail with the plain language because I think my brief covers that, but I would just...
Can I just ask a question, though? So let's take this analysis out of the specific facts of this case. I'm a state trooper, okay? And my neighbor doesn't like me, right? Doesn't like the state police at all. And goes to the Ethics Commission and says, hey, Walsh here violated the ethics of the state police because, I don't know, just something about her, right? A baseless, false allegation. But I get the notice, and somehow it's been screamed in by the Ethics Commission. They're looking at me to see if I violated the ethics by doing something off duty or something that my neighbor doesn't like and is making a deal of it and filing a complaint. I knock on the door of my superior officer at the state police and go, I'm doing my job. I did what you told me to do, and now my neighbor filed an ethics commission. What does the state police do?
I would say that under the statute, and I think the last paragraph...
No, I'm asking you, what does the state police do?
The state police can't do anything as it relates to indemnification, whether it be...
They defend.
No, they cannot. Under 9A, they cannot defend, and they can't defend under Section 9.
They say, go hire your own attorney, kid.
Unfortunately, yes, and I think that's how the legislature has written it, and I think
That's how it works.
Yeah, the last paragraph of Triplet is instructive. The SJC...
I know what the case law says. I'm asking you, that's how it works.
It does. And that's how the legislature has seen fit. You look at Marimon, and they talk about that the determination of the legislature in creating 258. Because when they created 258, what did they do? They lowered the shield of sovereign immunity for the Commonwealth. And they said, yes, you can sue the Commonwealth under 258, but these are the ways that you can sue the Commonwealth. These are the procedural guidelines that you have to sue them. You have to preside presentment. You can only bring it in certain jurisdictions. They created a vehicle for individuals to sue the Commonwealth. They decided to not include other types of actions, whether it be...
They knew under Section 9A that certain employment, state police, for example, or municipal police and other statutes, kind of runs the risk that there will be claims filed for intentional torts and civil rights violations.
Correct, and I think Marimon and Pinshaw talks about that.
And so the purpose of this was, hey, we don't want to discourage people, good people, from a profession because there's going to be kind of, by putting the uniform on, a risk that you're going to have to face claims. And in this instance, the claim was a civil rights violation. And it seems like it was shopped around to a whole bunch of different venues. And yet, protection for some and not for others, doesn't that kind of conflict with the purpose of protection under 9A?
I would respectfully disagree that the claim was a civil rights. There's an incident which an individual, based on that incident, elects to file a civil rights violation. Then, 3 years later, the State Ethics Commission conducts their own investigation and decides to go to show cause for violation of state ethics law. The fact that it stemmed from the same incident...
Arising from the civil rights,
Correct.
you would agree?
Arising from, I would respectfully say, arising from the same
From
incident.
the allegation of civil rights?
My reading of 268, the State Ethics Commission, is that you don't have to, there's no violation of an intentional tort or a civil rights violation for there to be a state ethics violation. The predicate requirements for the two are very different.
No, I could see in a case where it's bribery, right? You're not going to get defended and indemnified. But this one, there's no additional allegation. It seems as if the argument could be made, and has been made, that this arose from the civil rights. It's the same exact set of facts that they said, look at it through this lens, look at it through that lens. Sure, in a bribery case or some sort of other many ways in which ethics can be violated, I've read those cases, and it falls outside of the intended scope of protection. I mean, we're supposed to interpret the statute, not to come up with what is it, not ridiculous, but whatever the right language is that's escaping me right now, results.
What I would say, Your Honor, is that if the court adopts that interpretation, it cannot be just limited to incidents where there's also an ethics charge. As it was brought up in the Superior Court, it'd also have to apply to criminal charges. It would have to apply now that
Why? I mean, you have the language that says that it excludes willful, wanton behavior. I mean, I don't see how that the fear of including every single thing under the kitchen sink that we have to narrow our interpretation of the statute.
Well, I would say that looking at the instructions for Pinshaw, there has to be a specific determination made that something was willful, wanton, and malicious. And based on the standard that they use that in the context of civil rights violation, you could have an individual to engage in your hypothetical who is filed a public employee who has a civil rights lawsuit filed against them. They also stem criminal charges from that. There's the possibility that those criminal charges might not cover willful, wanton, malicious, which based on your hypothetical there would have to be indemnification as well.
No, then you'd have the right to reservation, right?
I would suggest the reservation, whether it was properly raised in the lower court, which I take the position that it didn't,
Understand.
that reservation only, Marimon and Pinshaw, when they're talking about reservation, they're talking about in the context of civil litigation, and whether it be for intentional torts or civil rights violation.
So you're representing that the motion did not raise the argument of a duty to defend?
My review of the record, my memory of the hearings in Superior Court, as well as review of the complaint and the record, I don't recall seeing any position that there was a that the issue of a reservation of rights, whether that is a bright line rule or not, for state agencies was raised at the lower court.
Judge didn't address it.
My memory, my review of the transcript, it was not raised. And the final point that I would make is I acknowledge that triplet focuses on Section 13 of 258. But the SJC did a very thorough review of 258 as a whole, the history of it, how municipal employees came into it. And they found, based on the plain language of 258, as well as, you know, the accompanying legislative enactments, that there's no mention of ethics charge, show cause, or even criminal complaint or criminal charge in 258. So I think it's difficult to accept the SJC's decision in triplet and then pull out that action in 9A results in indemnification for attorney's fees into an ethics charge. And I think that based on that, you can't narrow it down on ethics, that it's an expansion of 9A that's not supported by the case law or the plain language. If there's no further questions, I would rest up my brief.
I may not know the answers to this, but Colonel McKeon at some point had been a co-party with Major Anderson. He was allowed to appear, in this case, pro se. There was some indication that he had joined in her brief. I've not seen anything. Do you consider him part of this case?
Based on what I saw with the request to join the brief, I would, based on, you know, without.
Okay.
So I think the same the facts, quite frankly, the facts are stipulated to. The facts don't matter. It's a question of law whether 9A applies to an ethics commission hearing.
Thank you. We'll take the matter under advisement. Counsel, thank you both.
Thank you.
Our next case is the Department of Children and Families and Others versus Mother and Others, docket 24P 705. As you approach, I remind counsel that this case is impounded, so please do not use any names. And just so we're clear, and I can make sure my timekeeper knows, Ms. Swanson, you are going to take 10 minutes, and Ms. Lowe, you're going to take 5 minutes? Yes. Wonderful. Are we all set with that? All right, Attorney Joya, when you're ready.
Good morning, members of the panel, and may it please the court. My name is Ana Maria Joya, and I represent the appellant mother who is watching via YouTube live feed. My client is asking for this court to vacate the order of termination and remand for further proceedings. There are 3 main issues that I will discuss. The first one is mother's fitness at the time of trial. The second is the lack of colloquy at the trial for mother, an established native Spanish speaker who knew that the interpreter was interpreting her words incorrectly. And 3, virtual visits. Number 1, mother's fitness at trial.
I know you want to address that, but I have a preliminary question before you get there, which is in, I believe, the department's brief, they suggested that the issue with respect to the interpreter was waived. And you took the opportunity to file a reply brief, which was helpful, but you did not address the question raised by the Department of waiver. So could you give us your view on that, please?
Yes, okay. I will jump to the waiver. So one, mother being a Spanish native speaker.
Was that argument preserved below? The department says it was not. It's not properly before us.
So, Your Honor, I suggest that the fact that mother was a native Spanish speaker was a theme throughout the entire care and protection case.
Can you point to something in the record where her lawyer objected and said, the judge, you were supposed to do a colloquy and you have not?
So he did not do that.
Okay.
That is the record. He did not do that. But I suggest to the court that that is in fact what should have been done, because that is what the statute says. And that's not what happened. And throughout the underlining case, the care and protection case, mother's ability to not speak English was a common theme. DCF translated mother's action plans into Spanish. They had to use an interpreter to speak with her.
Can I ask a question? And I know that you wanted to start your argument on fitness, but I have a feeling that you're so familiar with this record, you can jump to, really, to me, a central theme of your argument is about the colloquy.
Yes.
So the first kind of 2 parts is you would agree with me that the colloquy applies to non-English speaking individuals.
Correct.
In this instance, I suppose we could take time and argue back and forth whether mom, who was the one who actually said, Spanish interpreter isn't doing it right, I'm going to speak English, qualifies as a non-English speaking person. But even if we say, accepting that she's a non-English speaking person, she got the interpreter. She chose not to use the interpreter, right? But the interpreter never left. I've been in busy courtrooms, and when someone says they don't need an interpreter and there are 10 other courtrooms that need the interpreter, that interpreter goes away. And then I think your argument of being deprived of something that she was entitled to. But am I wrong? When I read the transcript, and there were 2 days in which she spoke English and the combined other days she used the interpreter and spoke Spanish, the interpreter was always there.
Yes, the interpreter was always there, but that's not the way that the interpreters are supposed to be used. The colloquy should have been done. And if the mother said, I'm only going to testify now in English, the colloquy should have been done via the interpreter, should have been done on the record, and then the mother could have continued. But that's not what happened in this case. And the problem is that the judge made very specific findings of fact where he found, for instance, in finding of fact 77, mother's entire testimony regarding the events of January 17th, 2021 were inconsistent, illogical, and untruthful. And on page 28 of my brief, I also reference specific findings of fact where the judge references mother's credibility. And the problem with credibility in this case specifically is that it's via the testimony whether mother was either speaking in broken English or using an interpreter that did not interpret correctly. Mother testified for the first 3 days. The first day half of the day using a Spanish interpreter that wasn't doing it correctly, and then the days 2 and 3 completely in English. And the judge continuously made warnings to the mother, but that's simply not enough. It would have been no burden on the judge to simply say, okay, obviously there's a problem. Counsel has informed me that the interpreter isn't doing what they should be doing. Let's do a colloquy waiver, or let's find another interpreter. And that didn't happen.
So that's where I disagree. So I don't think the result necessarily would be, let's do a colloquy waiver because the interpreter isn't doing the job. It's for the attorney to say, Judge, we have serious concerns that interpretation is being done accurately. We're going to ask that a new interpreter be assigned to this case because I have information that the translation is not being done. That doesn't mean that because the argument would be, you know what, the state services wasn't that good, I'm going to have to go it on my own. That's not a clear choice, right?
Correct.
So that was never done.
So yes, that wasn't done, but the burden, the judge continued to put the burden on the mother and the attorney to basically figure out what parts weren't being translated properly and then bring that to the court's attention. And
the funny thing is that you have the juxtaposition in the trial transcript, the department is saying, no, because this could create an appellate issue. And it's the mom who says, no, this is what I want to do. I want to speak English. And the judge says, okay, I'm going to warn you, if you answer these questions, unless you use the interpreter because you're confused, I'm going to accept your answer for what it is. Right?
Yes, but correct, but those warnings are not enough. I would point this court to adoption of Ali, where in that case, yes, the parent continued to go through multiple attorneys, kept wanting to represent themselves, and the judge kept warning her, if you continue to go forward, if you continue to fire your attorneys, you're going to have to go pro se. You're going to have to go pro se. I'm just warning you, this is what's going to happen. And this court said that's not enough. A colloquy should have been done. And what we're asking is that the same thing should have been done in this case. Interpreters, I agree with Your Honor. Interpreters, the moment someone says, I don't need them, they're gone because they're in hot demand. Absolutely. And it's because of that hot demand that this issue should be addressed specifically, not in an unpublished decision as in adoption of Dave, but in a published decision. In adoption of Dave, that's the case that the appellees rely on. That case specifically deals with a parent who spoke English to their child, a parent who admitted to speaking English and admitted to knowing, understanding everything that the doctor was saying in a medical facility. In this case specifically, mother repeatedly needs an interpreter. She doesn't understand. And that is the problem. Mother did not understand. And it's unfair to say, well, now you have to figure out what parts aren't being translated properly. You have to figure out that with your attorney. The attorney doesn't speak Spanish. The client doesn't speak English. And it gets to the point where, yes, the DCF attorney is the one saying, no, 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 this shouldn't happen. But the DCF attorney goes as far as to say on transcript page 299, I want to bring to the court's attention as an officer of this court that I have a duty. I speak the language. I'm bilingual. If I suspect that something's not being done that's not being done correctly, I would have brought it to the court's attention. That's inappropriate. We can't expect DCF's attorney or any bilingual attorney to act as a filter / quality control when there's a statute specifically that says this is what should be done. We're not asking to reinvent the wheel. The statute...
You didn't raise an ineffective assistance of counsel claim.
Your Honor, the record is what the record is.
I'm not sure I know what that means in this context.
Well, the record, you're correct. I did not raise an ineffective assistance of claim.
Because on the one hand, I hear you blaming DCF. On the one hand, I hear you blaming the judge. On the next hand, I hear you blaming maybe her lawyer. So I'm trying to figure out, and I get it, you're advocating for your client, and I understand that. But if it was the lawyer's fault, then there should have been an ineffective claim brought, right?
So the fault is on the court. The court should have issued a waiver, and they did not.
What additional, in the waiver of counsel context, adoption of Ollie, there are certain things that are required in the colloquy when you waive counsel, such as the disadvantages of proceeding pro se. What additional warnings do you think the judge should have given here that were not already given?
So this very similar. What's going to happen if you go forward and you don't speak the language?
Didn't the judge say if you proceed in English, we're going to presume you understand the answers in English, but there's an interpreter. You can use the interpreter.
Yes.
What more? What does a colloquy look like? Because the statute doesn't specify what the colloquy should look like.
So the colloquy would have specified what's going to happen moving forward, and specifically whether the mother knew what she was doing, whether it was knowingly and voluntarily. So there are colloquies in DCF cases that happen throughout.
So the first part happened in form and substance, as Justice Shin has pointed out. So maybe we should focus on the second part, which is basically a knowing waiver.
Correct. So the knowing waiver. So for instance, after a 72-hour hearing, if the parent decides that they're going to waive the 72-hour hearing, there is a very detailed colloquy, and at the end the judge says, either I accept that you've done this knowingly and voluntarily. Do you know what that means? Have you had a chance to speak with your attorney? Has your attorney answered your questions? Do you have you been forced? Have you been promised anything? That's done. Then the case...
And do we have a case, a statute, a rule, on anything out of the juvenile court that tells us that what you've just described for a 72-hour hearing is supposed to take place in the context of waiving an interpreter?
No, that is what I am suggesting should happen. So that type of colloquy happens at the end of the 72-hour hearing. A very similar colloquy happens when a parent decides to stipulate to permanent custody. The same thing. The judge goes through the same colloquy all over again. Is it knowingly? Is it voluntarily? Do you know the consequences? Have you had a chance to discuss this with your attorney? Here, we have a statute that says a colloquy should have been done. I suggest to the court that that's what should have been done in this case, and it was not.
So the piece that's missing here, it seems as if, is the opportunity for a mother to speak with counsel. Although you could infer from the questions of, you understand that if you speak in English and you don't request any additional assistance and the answers come back in English, it's going to be assumed that you understood, right? And so that kind of knowing and understanding what the consequences of going without, assuming that she has a right to an interpreter, going without the interpreter. But again, her choice to go without the interpreter, because the interpreter was there and it was almost like a standby, right?
Correct.
So she could have then said, okay, and then spoken Spanish the whole entire rest of the time, right?
Yes, but the ad hoc use of an interpreter was inappropriate. That,
Well, translator services doesn't like it, that's for sure. They don't like to just do words and pieces and be standby. That's their policy. But what else? What other harm by having an interpreter ready, willing, and able, if she chose to use them? How does that equate to reversible error?
so the harm in that, again, is that the judge based his credibility on mother's statements, and it was during her testimony whether she sometimes used an interpreter and sometimes didn't, that he found her not to be credible. And that's harm to the mother because she was not able to properly express herself.
So sometimes witnesses in English don't express themselves well, right? And sometimes judges make determinations. Here, when I read the record, it didn't seem obvious to me that there was this great confusion, and the judge thought that the mother said, oh, I lived here. Instead, there was testimony of her running through her backyard, right? I mean, those types of credibility weren't because, were kind of choices that we give to the judge who hears the testimony. Or your claim is that, no, actually the judge was confused because of this language barrier. They pinned credibility on the confusion, but I don't see the confusion when it comes to that testimony.
So I see that I'm out of time, but I would reference the court back to the specific findings of fact that I list on page 28 of my brief that specifically address mother's testimony regarding the injuries of the child, that the judge did not find her credible.
Thank you.
And unless there,
Take the rest of your arguments on your brief, counsel. Thank you so much.
thank you so much.
Attorney Swanson, good morning, still morning.
Good morning. Good morning, Your Honors. Emily Swanson on behalf of the Department of Children and Families. Before we get into the merits of the termination decision, it seems that you're most interested in the language access questions.
Can we start with the question of waiver? It sounds like Sister Counsel said that, my words, not hers, I don't want to put words in her mouth, but that trial counsel did not object below. So if that's true, and you say it's waived because it's raised for the first time on appeal, but we are talking about a parent's constitutional right to parent. If it's waived, do we still reach it?
I would argue no, Your Honor. So I did realize that language access can be a constitutional due process issue, but we argue that even if she waived it, she is also stopped from raising this argument. Estoppel has two elements. You have to succeed on your position that's directly inconsistent with the position you're now raising on appeal. Here it was mother's idea to testify in English, and she did so over the repeated objections of the department and Children's Counsel. And second, again, the party must have succeeded in this position, and here mother was able to testify in English. And we argue that allowing mother to now raise this argument on appeal, especially where the department and the children's attorneys expressed a concern that allowing mother to testify in English would raise an appellate issue, would essentially allow mother to create her own grounds for appeal.
Judicial estoppel normally applies in the context of two different cases, right? Do you have any case where you apply judicial estoppel on appeal based on something that happened at trial?
I would agree with that in general, Your Honor. I was able to find two cases. I could look them up if you need me to, but.
No, I remember them, but they don't say that. They say judicial estoppel doesn't apply for a different reason, but they don't say it's appropriate to apply estoppel on appeal.
I would agree with that.
It seems like normally we see it in the context of an invited error argument.
I think that the cases that discuss judicial estoppel tend to discuss it very broadly. And one of the cases, I think, specifically says that judicial estoppel should be applied in any situation where a party is attempting to use the justice system in a way that it wasn't intended to. And I would argue that using an issue that you created on your own over the objections of the other attorneys to raise an appellate issue would be an example of using the court in a way it's not supposed to be.
Let's assume for a moment that we decline your invitation for judicial estoppel.
Yeah.
On the merits.
So on the merits, as I listed in my brief, there's several reasons why her argument fails. First, I think there's plenty of evidence here that Mother was an English speaker and didn't qualify for the right to an interpreter under Section 2. The case law is pretty clear that you don't have to have English as a first language in order to be an English speaker. Specifically, there's evidence here that Mother, first of all, she testified over 2 days in English with minimal assistance from an interpreter. So that's pretty compelling evidence on its own that she was a proficient English speaker. But in addition, there's evidence in the record of Mother speaking in English outside of court as well. Specifically, in one of the court investigators' reports, it was noted that she was fluent in English. She spoke to the shelter manager in English. She spoke with her social worker. There's testimony from her social worker that she communicated with Mother in English without major issues. And there's also testimony from Mother herself that she spoke mostly with her son at visits in English. So there's plenty of evidence here supporting the judge's, I would say, implicit finding that Mother was an English speaker and didn't need the interpreter to begin with. Even if the panel were to disagree with that, I would say that even if she was even if she had the statutory right to the assistance of an interpreter, she had the assistance of an interpreter at all points during this trial. The actual statutory right says assistance to an interpreter. There's not a whole lot of case law interpreting that statutory language, but just because the interpreter's office has a policy against the ad hoc use of an interpreter, there's nothing in the statute that specifically says that an ad hoc use of an interpreter would not qualify as the assistance of an interpreter to fulfill that right. And then finally, even if the panel were to agree that she waived her right by testifying in English with the assistance of an interpreter, I would still argue that the essential requirements of the waiver under Section 3 were met here. Specifically, the judge gave her multiple warnings about the effect of her decision to testify in English, gave her every opportunity to back out at 3 different points during trial.
Do you think that if there had been a colloquy, it would have required the judge to ask her if she was making a knowing and voluntary waiver of her rights to an interpreter?
I think that the statute doesn't specifically say what the colloquy needs to consist of, unlike some of the other examples that have been brought up, especially with the right to, or the waiver of the right to counsel. The requirements here are much less specific. And even if that might have been best practice, I would argue that the essential requirements are here, and Mother was not prejudiced by an on-the-record finding that her waiver was knowing and voluntary. Specifically,
if we agree with you that the mother has not met her burden to show she was a non-English speaker, does the analysis stop there?
In terms of the statutory right to an interpreter, I would say yes. Mother does.
She raises a due process.
She raises the specter of a due process argument. I would say that even with the due process argument, her argument fails. First and foremost, for a due process argument, you need to identify what other steps could have been taken to lessen the chance of her deprivation of due process. Here, if we're saying that the risk came from mother not being a native English speaker, the procedural protection that was offered to her, i.e. the qualified interpreter, I think lessened any, whatever risk was there that she might actually not be able to fully participate in trial. So I don't think that her due process argument really raises.
Can a judge force someone not to speak English? In other words, if there was a due process infringement or violation, wasn't it caused by her own choice? The judge didn't force her to not use an interpreter. In fact, provided one the entire time. And if there was any resulting prejudice, was it anything of a governmental entity that violated her due processes, or is it her own?
No, Your Honor, I think that goes back to my estoppel argument, is that she created the prejudice here, and she shouldn't be allowed to seek a new trial based on prejudice that she created for herself. If there are no more questions on the language access issue, I am going to leave the bulk of the merits issue to my sister counsel here, but I did want to touch briefly on the virtual visit issue. Mother specifically argues that the judge was wrong to count mother's virtual visits against her. I think just 2 quick points on that. First, there is no law that says that the judge wasn't able to hold her virtual visits against her if he so chose to. The case that mother cites, Thaddeus, actually held that in-person visits are especially important to reunification efforts by the department, especially for infants and children, but that the parents' right to in-person visitation can be outweighed specifically by the COVID-19 pandemic and the risk of spreading disease. But I think more importantly in this case, mother's argument ignores the several parts of the judge's finding and conclusions that credited mother with being fully compliant with her visitation schedule, especially when the judge was going through all of the statutory factors. He specifically said that the willful visit or the willful failure to visit with her children was not being held against mother. If there are no more.
I have to leave it there, Attorney Swanson. Thank you.
Thank you.
Attorney Lowe. Still morning. Good morning.
Still morning. Thank you. Good morning, Your Honors. Allison Lowe on behalf of the 3 children. May it please the court. The children today are ages 6, 5, and 3.5. I am going to address the majority of my argument to the issue of unfitness and the sufficiency of the evidence, but I did want to respond to one question that you asked Chief Justice Blake about if Your Honors found that the interpreter issue had been waived, because it involves constitutional rights, should it still be considered? And I would point the panel to the case of adoption of Jacob, which is found at 99 Massap Court 258. It's a 2021 case that stands for the proposition that a party is not entitled to present an argument on appeal on an issue that was not presented to the court below. It does go on and address if the issue is in fact waived, can that waiver be overlooked? And what the court stated is that it could possibly be overlooked if it presents a clear injustice. And I would argue here today that there has been no clear injustice on the interpreter issue. The mother at transcript page 101 affirmatively and unequivocally asked to testify in English. The judge gave her a number of advisements, which I address in my brief, basically telling her, you need to understand that your answers are going to stand, and I'm going to presume that you understand the question. And those were the functional equivalent of a colloquy. And the mother and her attorney to each of those advisements responded, understood, agreed, okay, and persisted in the request to testify in English. Just two other quick points on that. There is other record evidence of the mother's language ability. She herself told the court that she had previously testified in English at a prior hearing with an interpreter standing by. And also the social worker who had worked with the mother for the year preceding trial testified that she had never needed an interpreter with mother, that they spoke in English, and that mother had told her that she spoke English just fine. So turning, Your Honors, to the issue of the mother's unfitness, the children are asking that the court affirm the lower court decrees finding the mother unfit and terminating her parental rights. Somebody in a small circle of caretakers fractured this child's skull when she was 11 months old. And it was determined that that fracture resulted from non-accidental trauma. The mother saw the bruising and swelling to her daughter's face, but she didn't respond, at least not immediately. She saw and heard in photographs and a video that she received, she heard her daughter whimpering and, in the mother's words, complaining, and she failed to seek medical care, at least not immediately. She provided a number of explanations for how the injuries could have occurred, and those explanations shifted over time from different people. She told different people different things at different times. And she never asked anybody in that small constellation of caretakers, what happened to my daughter? At the time of trial, 2.5 years later, the mother still maintained that non-accidental trauma was just one of the possibilities that she was considering as the cause of the injuries. And that in and of itself demonstrates a very serious lack of insight and reason to believe that the mother would not be able to protect the children in the future. The children waited 2.5 years, Your Honors, for the mother to recognize how she contributed to the harm that her daughter suffered, and what could she do to recognize and protect them from harm in the future. And ultimately, she was unwilling or unable to do so. She failed to participate.
No one was ever charged, right?
No one was ever charged, Your Honor. She failed to participate in all of the substantive services that could have supported her in developing insight. The only service that she completed was a parenting group when she was at the shelter in Brockton, and then she did complete another parenting group when she got to Puerto Rico, but there was evidence that those parenting groups were not specific to a traumatized child.
Let me check to see if the panel has any questions for you.
I had one improper question because it's outside the record. But if you know, is the second child now back in the same foster home as the other two children?
Yes. So part of my, if Your Honor has another question after my response, that would require me to go outside the record. But what I can tell the court is I was out to the home on Saturday. The children remain in the same placement, and they continue to support the goal of adoption.
Thank you. Very difficult case, excellent briefs, excellent arguments. The case is under advisement. Thank you all. Our final case it's now this afternoon. This afternoon is Wendy Swillinsky versus the Town of Aquina and another 23P 892. So just because I think that you all were not necessarily in the courtroom when I gave my instructions this morning, I'm just going to go over the rules of the court, which is that each side is permitted 15 minutes of argument. You will argue from the podium, and you will see there is lights on the podium. The green light will turn on when you begin to speak. The yellow light will come on, warning you that your time is up, almost up, excuse me, and the red light will indicate that it's time for you to stop, and we'll let you know whether or not we want to ask any additional questions. When the appellant presents, the appellee does not speak. When the appellee presents, the appellant does not speak, and then there is no rebuttal, so you can't have a chance to rebut what the other person said. We have read all of the materials, so we know what the legal issues are, we know what the factual issues are, so you should try to use your 15 minutes to tell us what you want us to know about your case. With that said, Mr. Amos, you may have a seat. Ms. Swillinsky, if you would come to the podium. And the light will turn on when you are ready to begin your case.
Members of the panel, may it please the court to introduce myself, Plaintiff Wendy Swillinsky, pro se. This appeal involves the illegal taking of my property. The incorrect determination of the statute of limitations has expired. Mass General Law 7918 to be applied. The state's transfer of the land only with exampled facts to support it. Ownership prior to Rose starting in 1939, and my request for a rightful remedy and a wrongful taking. The judge errs in stating in the first count only seeks damages under Chapter 7914. Actually, count 1 seeks damages from a broader Chapter 79. By limiting my damages to only 7914, an error was made. The first sentence of the complaint reads pursuant to Mass General Law 7910 and 14, as well as the Mass Declaration of Rights 10, 11, 12, 14. Without notice, due diligence, due process, and without legal cause, the town of Aquina voted to take my shack. I had a valid legal continuance from November with the planning board to move the shack until February 11, 2014. The vote was taken December 2013. They did not check the status with the planning board. They did not call or write me to ask, and the selectman's rep to the planning board, who attended all 6 meetings between July and November, yet reported nothing was going on. Engineers were hired, plans were drawn and presented, permit letters written. I was in total compliance and timely. Additionally, the town of Aquina took this property that was not wholly in their town. In fact, the shack in Lot A is 75% in the adjacent town of Chilmark. The agenda for that meeting did not reflect a shack taking. The agenda read shed update, not shed taking. The public was not made aware there was going to be a taking of someone's property. This taking was without substantial government interest or even the use by the public. It was just handed over to the leaseholder of Lot A, who was a family member. Statute of limitations. The finding that the statute of limitations has expired is incorrect. Mass General Law 7918 should be applied. We brought it up in the opposition to summary judgment argument and then again before the judge at the Zoom pre-trial hearing. The judge does not mention or comment of this statute being applicable. Yet all the prerequisite parts are satisfied. A 6-month refiling from an earlier suit involving the same question, failure for want of jurisdiction, cause not decisive of the merits. The judge agrees about the same question, the facts which preceded this instant action concerning the same subject matter. She goes on to say the federal case judgment involving the same issue of a taking. The suit was filed 4 months after the federal decision. It failed for want of jurisdiction. Federal Judge Burroughs, quote, says, Swillinsky's failure to exhaust her state remedies is dispositive. She instructs, to the extent Swillinsky could demonstrate her ownership of the shack and exhaust her state remedies for just compensation, her unconstitutional takings claim could have merit. The jurisdiction into federal court was the wrong place for the case. I filed back into Superior Court again, the correct jurisdiction to exhaust my state remedies. The judge states...
That in July of 2019?
Yes. The judge states this court does not understand this to mean that Swillinsky can start anew. It's a flawed conclusion considering Federal Judge Burroughs says I am to exhaust my state remedies. Finally, it reads, which fails for defect of form or other cause not decisive of the merits of the controversy. Judge Rufo, in the denial decision on the motion to dismiss, clearly states the USDC decision was solely based on the plaintiff's failure to exhaust her state remedies. Plaintiff's claims have not received final judgment on the merits. Other avenues for statute of limitation is Judge Rufo viewed the taking as a Chapter 79 eminent domain without proper procedures adhered to. The town voted to take the shack. There was no recording of the taking of the shack, therefore there is no vesting date for the time to file according to the eminent domain statutes. The attorney for the town admitted no procedures were taken under that statute. Yet when asked by what authority has the taken been done, no answer was given. Other alternative vesting dates is November 8th, 2017 for a 3-year time to file. My ownership rights did not end until the final Aquina Planning Board vote that denied the move. The December 3rd, 2013 date is not a legitimate date. That was the date of the vote, original vote to take. The taking was not lawful. The Cornell law definition says a vested right, interest, or title must be absolute, fixed, and not subject to being taken away. The town does not have absolute ownership. With the lawsuit filed, that right could be taken away. The Superior suit was removed to federal court. It was not dismissed or terminated. By definition of removed, it simply changed courts, meaning it was still ongoing. The clock had not stopped until the federal decision was issued. The town recognized my ownership rights during mediation of that suit, and I hope you can understand that it's very difficult for me to consider a statute of limitations would even be an issue when I have been in a constant lawsuit for 12 consecutive years. Ownership. I bought the shack from Rose after the selectmen voted a lot swap months earlier.
Did you ever record a deed?
No, the shacks have no deed.
Did you ever pay real estate taxes?
I did not own the shack during a calendar year to have that. I bought the shack in April, and the July 1st is the fiscal year start. So I was.
You say you only owned the shack for 3 months?
I had only bought it for 3 months before.
So you've never paid real estate taxes on it?
On the shack, no.
And you've never had a deed recorded in your name?
No.
Okay.
There's no deed. Yeah, there are.
Are there any closing papers between you and Rose to show that you purchased it?
We have a bill of sale, yes.
And do I understand that you made partial payment but not full payment?
Correct. That was the terms of the bill of sale.
And has Rose come after you for the rest of the money?
No, I paid it. I paid it in full. It was a 5-year payment, and she was paid to all her total monies before she died. I bought the shack from Rose after the selectmen voted the lot swap months earlier. I relied on their vote before I bought the shack. They rescinded the vote weeks after my purchase, not as the judge summarizes in her background. To have a taking, there must be ownership. The town of Aquina has owned the land, but never the shacks on it. I've shown the shack has been privately owned by a succession of individuals for 85 consecutive years without objection from the state or town, starting in 1939, well before Rose's ownership. The judge's conclusion that the earlier ownership does not show a clear chain is erred. Without having deeds and titles to rely, these earlier ownership records do support a clear chain. The facts show shack ownership has always been on separate land of the state and town. Separation examples are Gardner's permit, Fenner's bill of sale, Murphy's Lot F permit, Flanders land court title to the cottage only, Rose's lease, and my lease. Other evidence not allowed is Stephen and Rebecca Gardner's probate wills. The town has admitted it has no records that it owns the shack in any of these 85 years. The state created the land by dredge spoils from a channel dug. In 1939, the first located owner, Stephen Gardner, has a permit from the state to use an area number 15. It doesn't mention the use of a building. The rent is $5. In 1952, there's a bill of sale from Dora Fenner as executrix of the estate of Rebecca Gardner, Stephen Gardner's wife. The shack is sold to Louis B. Shirtliff. The bill of sale describes one boathouse located in the towns of Chilmark and Gay Head on property of the Commonwealth, designated as Lot 15 in a plan attached to the permit, the same permit number that Stephen Gardner had in 1939. It is decisive and clear. The boathouse is owned personally, separate on property of the Commonwealth for the third consecutive time. Unlike the opinion in the decision, this bill of sale does connect 3 owners to the shack and enforces its location on state land. In 1970, the state transfers the land to the 2 towns, Aquina and Chilmark. The deed clearly defines this transfer as a parcel of land. It is parcel of, and it further describes this parcel of land is no longer needed by the Department of Public Works. There's no mention of shacks, docks, sheds, buildings, or any of the equipment that's sitting on this land. In this same chapter 485, other parcels of land on the Cape were included in land transfers. Each transfer starts with a parcel of land, but 5 of those entries then add "and a memorial marker thereon." If this Menemsha transfer was to include the 10 shacks and docks, the language would have also stated "and shacks thereon," as it did for the memorial markers. It's very clear the state's intent was to transfer land only and not the associated buildings on them. After the transfer, nothing changed with the individual ownership or sales of the shacks in both towns. It's unreasonable for the town to conclude the shack is town-owned just because it sat on land during this transfer when there had been 3 prior sales of the shack alone. The judge used the case Tuer versus the Town of Essex to be particularly instructive in her decision, but there's an exception to that ruling. If a person claiming ownership of a structure can show that there was an agreement with the town that the structure is actually personal property which can be removed from the land, Rose's lease with the town satisfies that exception with numbers 9 and 17. The judge wrongfully concludes there is no evidence whatsoever of an agreement between Rose and the town regarding the shack. It's totally false. Rose has a lease with the town. The judge is aware of this lease and refers to it on page 2 and 3 of her decision.
Did you ever rent the shack?
I used the shack.
Or did you lease it?
No, I did not pay rent for it. The engineer stated the shack can be moved easily. The shack measures 12 by 16. It's not affixed to the land. It doesn't have a foundation, plumbing, or a septic. 5 years after the state's transfer of land, Alfred Vanderhoop buys the shack from Mr. Shirtliff. It passes to Ms. Rose by his will and trust. As new owners of the land, there's no objection or comment from the town on this sale to Vanderhoop. The probate court in the trust suit against Rose allows Rose to sell the shack. The trustees waive claim to the bill of sale to Swillinsky and all monies past and future. The court does not question Rose's ownership right, but allows her as owner to sell the shack. It is reasonable to conclude the probate courts viewed Rose as the owner of the shack since the bill of sale is between Rose and Swillinsky only. More acknowledged separations was Lynn Murphy's 1960 permit from the state on Lot 3, was to use and occupy an area of land, and the final paragraph reads, "Permittees shall remove any and all structures owned by them located on the premises." The state clearly recognized the personal ownership of the structures on their lot. The land court case in 1982 finds Flanders had title to the cottage only. The land belonged to the town. All of this is proof enough that structures have never been owned by the state or the town. In the remedy, the judge wrongfully states and dismisses in her discussion that the sole exclusive remedy is Chapters 79, 10, and 14, with no independent cause or action under the Mass Declaration of Rights. Yet the Mass Declaration of Right, Article 10, in part states that no property of an individual can with justice be taken from him or applied to public uses without his own consent. I gave no consent to take my property. Then it goes on, when the public exigencies require that the property of an individual should be appropriated to public uses, he shall receive a reasonable compensation thereof. It seems clear to me that that article does provide a reasonable compensation in the Declaration of Rights. And I think that's it. Yellow light, I'm
Let
close.
me see if we have any other questions. I don't see any other questions from the panel. Thank you so much.
Thank you.
Please stay and have a seat right at that table while we hear from Mr. Amos.
Madam Chief Justice, and may it please the court, Justin Amos on behalf of the town and its select board. I wanted to pick up real quick, Chief Justice Blake, on a question that you had asked to Ms. Swillinsky about the payment and assessment of real estate taxes. There's also nothing in the summary judgment record that the prior leaseholder, that being Camille Rose, who leased Lot A from the town, was ever assessed real estate taxes related to the shack, that she ever paid real estate taxes with respect to the shack, or that there was ever a deed recorded in any registry of probate with respect to that shack that's located on Lot A. Pivoting off of that, just to dive right into the ownership of the shack on Lot A, for either of two independent reasons, Judge Sanders was correct in ruling that the town owns the shack. The first being that it is the general rule that any fixture fixed to land becomes a part of that realty unless there's a clear agreement between the landowner and the person claiming personal property that it was intended to retain its status as personal property. Here, there is no agreement between the Commonwealth or between the town with respect to any of the people that Ms. Swillinsky has claimed owned the shack dating back to the late 1930s that showed that the shack was intended to be treated as personal property. And I actually think that the absence of any language in first the special act by the legislature, and I believe it was 1960, authorizing the conveyance of these lots to the town as well as to Chilmark, and in the deed that was ultimately executed in 1970. The fact that there's no reference to the shack, I actually think inures in our favor, because if any party believed that the shack should retain personal property rights, one would expect to see in that deed or in that special act a specific agreement that it retain that.
What's the evidence that it's affixed to the land?
So the shack is on, I think it's a 2-foot foundation. It's a stone foundation, actually quite similar to what the land court held. It was the Gay Head case that Judge Burroughs relied on, and as I think it's analogous somewhat to the cottages in the Tower versus Town of Essex case, that they were not on deep foundations on the beach. Obviously, they were on pilings. The fact that it is affixed to some type of foundation, I think, is sufficient.
Where is that in the record?
Well, I mean, part of that problem, Your Honor, is we don't have a record. And unless there are questions, I'll rest on my brief with respect to that argument. We clearly don't have an adequate summary judgment record upon which to reverse.
In your 9A statement, it was alleged, it was stated that there was a foundation, it was fixed to a
yes,
foundation.
Your Honor.
If we determine that Ms. Swillinsky did not own the shack, is that the end of the case?
Yes.
Do we have to reach the due process, the Declaration of Rights argument?
Well, I think you do have to reach it, but I think there's no real dispute that there is no private right of action that the SJC has ever recognized directly under the Declaration of Rights. There are two cases, Phillips and another that the name escapes me, that held essentially for the proposition that where there's no statutory claim through which you can vindicate those rights, then maybe we would find a direct action. Here, Chapter 79 is that comprehensive regime, and the SJC has acknowledged that in the Bromfield and the locator services cases. Those are cited on page 10 of my brief. So I don't think there is really any dispute that you cannot bring a claim directly under Article 10. So I think you have to address it because it's raised. It's a separate claim that was asserted in the Superior Court, but the case law, I think, forecloses that.
So if we go back to Justice Shin's question about a structure affixed, if it's not a structure affixed, it's personal property and the statute still has run.
Yes. Yes, if you can show, because if it's not the real estate itself and it's not affixed by default, it's personal property, and the statute of limitations doesn't turn on whether it's personal property or it's real estate. So the petition, the select board, or the body politique under Section 10 is a 1-year statute of limitations, and then to file a petition in Superior Court is a 3-year under Section 13, and that can be filed regardless of whether you first filed the petition with the body politique.
Do you agree that the latest possible vesting date is 2/3/14?
Yes. I think that it is earlier. I think it's the December 3rd, 2012.
If I'm saying the
But
latest.
yes, we would, I think the most favorable reading of the record would be it was in February when the Select Board sent the letter both to Ms. Rose and Ms. Swillinsky and then voted to reaffirm that they were awarding the lease to someone other than Ms. Rose and Ms. Swillinsky, which would then, sorry, Your Honor.
What is your response to Ms. Swillinsky's claim that the federal action, these are my words, not hers, but essentially told the statute of limitations?
So we'd have no case law interpreting Section 18 or that savings clause, so we're in a little bit of uncharted territory. What I think is important to recognize about the history of this case is that it was filed initially in December of 2013, asserting only common law claims, promissory estoppel, breach of contract, tortious interference. I believe it was 3 years later, in 2016, it was amended to assert unconstitutional taking under the Fifth Amendment and directly under the Declaration of Rights. And then, the First Amendment complaint didn't specify, just said an unconstitutional taking. And then I believe it was in April of 2016, amended a second time to assert under Article 10, under the Fifth Amendment, and also to assert a Section 1983 claim and a Section 1985 conspiracy claim, at which point we removed it. At no point in time was Ms. Swillinsky unable to have filed a Chapter 79 action timely. And I think that's what distinguishes this from the language of Section 18. The purpose of that is if I filed in the wrong county, right? I file a Chapter 79 claim in Barnstable County instead of Dukes County. And the judge says, I have no venue here. I can't oversee this case. I'm dismissing without prejudice. That savings clause is intended for you to then go file to the correct court. What it's not, I would suggest, it is not intended to allow a party like was done here
To bring a new claim.
to bring an entirely new claim that could have been brought in any of the prior 9 years of the litigation, to lose its summary judgment, to not appeal, and then to file the second action. That I think the downstream result of that kind of interpretation would incentivize plaintiffs, not specifically talking about Ms. Swillinsky here, but any plaintiff to hold back, right? You hold back some claims because if you lose your principal ones, at least you get to refile in a different venue within those 6 months. And I just don't think that that's what the legislature intended with respect to Section 18. And the last thing I'll say, unless there are any further questions, is even if this was personal property, Ms. Rose failed to remove it from the Lot A prior to the expiration of the lease. And even within that time, Ms. Rose sold to Ms. Swillinsky the shack. We accept that that sale was proper and was actually done. Ms. Swillinsky did not remove the shack from Lot A before the expiration of the lease. And as the case law has recognized, it's the duty of the person claiming personal property to remove it prior to the expiration or within a reasonable time thereafter. The shack still sits on Lot A.
Is there any evidence or anything in the Rule 90 statement that shows that it can't be removed, physically can't be removed?
I don't believe so. What the planning board voted, to the best of my recollection, is that to remove it would be costly and that it would lose its historic character, but not that it physically could not be removed.
Okay, because at least under the tour, the concept of a fixture, we usually look at whether removing it would cause injury to the actual land or the structure, right?
Correct, but if it's affixed to the land, which it is here, and has existed, I think was undisputed, as Judge Sanders recognized, for over 100 years in this place, being used by and for the benefit of commercial fishermen, that it was affixed to the land, whether it's a fixture or just simply a part of the realty. Because if you look at the Tower case, it talks not only about fixture, which is kind of a Russian nesting doll of arguments, but the principal argument is when somebody builds a structure on the land of another, that structure becomes a part of the real estate. So that's our principal argument, is that this was built on land that, at least going back into the late 20s, or pardon, early 20s, belonged to the Commonwealth. And there's no evidence in the record about who built the shack. We just know that it existed at the very latest in 1938, because it was on a DPW plot plan following a hurricane. If there are no other questions, Your Honors, I'll rest on my brief.
I don't see any. Thank you both very much. The case is under advisement. You will get a written decision. Thank you.
Thank you.
That ends today's list, and I'd like to thank our